The Director of Public Prosecutions, Noordin, Haji, has ordered the arrest of Treasury Cabinet Secretary Rotich, among other top government officials, over the multi-billion-shilling Arror and Kimwarer dam scandal. Top government officials are said to have bent the rules and misled the public about the state national finances in order to award the tender to the bankrupt Italian firm CMC Di Ravenna. The company was to finance the Arror and Kimwarer Dams project, but the Kerio Valley Development Authority and the National Treasury went ahead to spend 20.5 billion Kenyan shillings on the taxpayers' money on the ghost projects.
Most importantly, our message to every hardworking, law-abiding Kenyan, those who play by the rules and pay their taxes, is we are going to stand by you. On 18th September 2018, the Director of Criminal Investigations received complaints touching on governance and operation challenges in the management of the two dams projects, Arror and Kimwarer, that required urgent attention. Upon investigations by the DCI, it was established that the conception, procurement, and payment process for the Arror and Kimwarer dam projects in Elgeyo-Marakwet County were riddled with massive illegalities. Having established this, the DCI and I set up a joint team that conducted further in-depth investigations which revealed that several persons and legal entities committed criminal acts and omissions. In late February 2019, I received a preliminary investigation report, and upon review, I directed on the 8th of March 2019 that the breaches of the law disclosed and their consequences were serious and merited a detailed and thorough investigations. I further directed that the joint team fast-track the investigations and engage international partners. In June 2019, the DCI submitted the investigation file to the ODPP for direction. The investigations established that government officials flouted all procurement rules and abused their oath of office to ensure the scheme went through. Many procurement procedures as stipulated by the law for such projects were ignored, and the law was circumvented to ensure that CMC Di Ravenna got the contract. KVDA, Kerio Valley Development Authority, chose Public Procurement and Disposal Act 2005 for the concession agreements, despite the fact that the law in 2013 prescribed public-private partnership. The officials who should have pointed this out failed to do so and went ahead to award the contracts to CMC Di Ravenna of Italy to run concurrently, while aware that the firm was at the time of award straining and getting into voluntary liquidation back in Italy. We also note that the same firm had been awarded 3 other mega dam projects that are either incomplete or are yet to commence. KVDA management failed to comply with the principle of value for money, which demands that there be competition among suppliers, efficiency and effectiveness in the procurement process, fairness and non-discrimination, integrity, transparency, and accountability. This was in flagrant disregard to the laid down public procurement laws, regulations, and rules, resulting in massive loss of public resources. Whereas the alleged commercial contract signed between KVDA and CMC Di Ravenna, Itenera joint venture, clearly states that Kimwarer Dam would cost US dollars 204 million 020,149.02, while Arror Dam would cost 252,188,732.27 million dollars, totaling to US dollars 456,208,881 million dollars, approximately Kenya shillings 46 billion. The National Treasury negotiated a commercial facility increasing the amount to approximately Kenya shillings 63 billion, which is 17 billion more than necessary or required, payable on a timely basis without regard to performance or works. We now also know that CMC Di Ravenna submitted draft technical designs in February 2019, 4 years behind schedule. Further, the National Treasury entered into a facility contract in euros, while the commercial contracts were in US dollars, therefore occasioning further loss to the Kenyan government through exchange rates. Of note, out of the Kenya shilling 63 billion in respect of the projects, as at January 2019, the government of Kenya has made the following payments: advance payment, commitment fee, insurance and other costs totaling Kenya shillings 19,714,366,991. Out of this, Kenya shillings 11 billion for insurance was paid upfront. In contrast, if the borrowing was justified, a government guarantee would have sufficed at no cost to the government of Kenya and Mwananchi. Further, euros 40 million, approximately Kenya shillings 4.6 billion, was borrowed in addition to the principal amount to pay interest in advance during the construction period, which to date has not commenced. As a country, we continue to pay interest on the loan. I don't know if you've understood this point. We borrowed, the loan had interest, we borrowed more money to pay the interest, which also attracted interest. I hope that's clear. A further Kenya shillings 643 million was released by the National Treasury as counterpart funds, which was intended for the resettlement of the persons that would be affected by the said projects as compensation for the land acquired. However, there is no evidence that land has been acquired 4 years down the line. Furthermore, Kenya Forest Service, in a bid to protect our environment, strongly opposed any excision of land or forest land, pointing to significant adverse impact on the forest ecosystem. Based on expert opinion, if this project was carried out in strict adherence to the law and existing policies in place for safeguarding the public interest, it should not have cost Kenya shillings 63 billion. The evidence established malpractices that impacted on our public debt. A Treasury report dated 3rd March 2017 opined that, and I quote, if this borrowing is converted into Kenya shillings at the prevailing rate of 106.2, it translated to approximately a loan amount of shillings 61 billion. Added to the GOK total public debt stock of Kenya shillings 3 trillion as at 27th February 2017, debt stock increases of Kenya shillings 4 trillion, equivalent to 52.9% in the net present value of debt to GDP, which is above the limit of 50% provided for in Section 26(1) of the Public Finance Management Regulations. This advice was ignored. It is a high betrayal of public trust to disregard and breach public debt regulations. This kind of crime and irresponsibility enslaves us with unnecessary debt and mortgages our future generations. The persons we are charging today were mandated with safeguarding our public interest and deliberately breached this trust. Not only bound Kenya to a loan, but they ensured that the funds did not come into the consolidated fund, in effect guaranteeing that no one was oversighting its use. They broke the law on public finance management under the guise of carrying out legitimate commercial transactions. Colossal amounts were unjustifiably and illegally paid out through a well-choreographed scheme by government officers in collusion with private individuals and institutions. Upon receiving and reviewing the evidence, I am satisfied there is sufficient evidence to charge and prosecute the perpetrators. It is instructive to note that the national prosecution policy requires the evidential test to be met before the public interest can be considered. Therefore, in applying the evidential test, one must consider all the evidence and information availed to the prosecutor. And in concluding that it is in the public interest to prosecute these cases, I have considered that such infractions are crimes against mwananchi, individually and collectively, and the decision to prosecute is in line with safeguarding the public good. This decision has been made professionally, independently, devoid of any external influence, political consideration, or any other extraneous matters. Consequently, I have today directed the DCI to effect the arrest and immediate arraignment before court of the accused persons named below herein. 1. Henry Kiplagat Rotich, Cabinet Secretary, National Treasury. Kamau Thuge, Principal Secretary, National Treasury. Dr. Susan Jemtai Koech, Principal Secretary, Ministry of East African Community. David Kipchumba Kimosop, Managing Director, Kerio Valley Development Authority. Kennedy Nyakundi Nyachiro, Chief Economist and Head of Europe 2 Division, National Treasury. Jackson Njao Kinyanjui, Director, Resource Mobilization Department, National Treasury. Titus Murithi, Inspector General of State Corporations. Paolo Poselli, Director, CMC Di Ravenna. CMC Di Ravenna Itinera Joint Venture Italy, CMC Di Ravenna Itinera Joint Venture Kenya. William Kipkemboi Maina, Head of Supply Chain Management, KVDA. Paul Kipkoech Serem, Manager Engineering Services, KVDA. Francis Chepkonga Kipkech, Tender Committee, KVDA. Samuel Kimutai Koskei, Tender Committee, KVDA. David Juma Onyango, Tender Committee, KVDA. Patrick Kipto, Tender Committee, KVDA. Elizabeth Kebenei, Tender Committee, KVDA. Esther Jepchirchir Kiror, Tender Committee, KVDA. Moses Kipchumba, Ad Hoc Technical and Financial Evaluation Committee, 2, KVDA. Engineer Nelson Korir, Ad Hoc Technical and Financial Evaluation Committee, 2, KVDA. Engineer Isaac M. Kiiru, Ad Hoc Technical, Financial and Evaluation Committee, Team 2, KVDA. Engineer Patrick Kipsang, Ad Hoc Technical and Financial Evaluation Committee, Team 2, KVDA. Frederick Towet, Ad Hoc Technical and Financial Evaluation Committee, Team 2, KVDA. Jotham Ruto, Ad Hoc Technical Financial Evaluation Committee, Team 2, KVDA. Charity Mui, Ad Hoc Technical and Financial Evaluation Committee, Team 2, KVDA. Geoffrey Mwangi Wahungu, CEO, National Environment Management Authority. David Walunya Ongare, National Environment Management Authority. Boniface Mamboleo Lengisho, National Environment Management Authority. For the following offenses. 1. Conspiracy to defraud contrary to Section 317 of the Penal Code, Cap 63 Laws of Kenya. Failure to comply with applicable procedures and guidelines relating to procurement contrary to Section 45 2B as read with Section 48 of the Anti-Corruption and Economic Crimes Act No. 3 of 2003. Engaging in a project without prior planning contrary to Section 45 2C as read with Section 48 of Anti-Corruption and Economic Crimes Act No. 3 of 2003. Abuse of office contrary to Section 46 as read with Section 48 of the Anti-Corruption and Economic Crimes Act No. 3 of 2003. Committing an offense of financial misconduct contrary to Section 197(1) or I of the Public Finance Management Act No. 18 of 2012. Fraudulent acquisition of public property contrary to Section 45(1)(a) as read with Section 48 of the Anti-Corruption and Economic Crimes Act 2003. Knowingly giving a misleading document to principal contrary to Section 41(2) as read with Section 48 of Anti-Corruption and Economic Crimes Act No. 3 of 2003 of the Laws of Kenya. Willful neglect to perform official duty contrary to Section 128 as read with Section 36 of the Penal Code.
Reporting for the Kenya Digital News, my name is John Matava.